dear aspirants, welcome to Epitome here. So we are doing this UPSC PYQ analysis, especially topic-wise PYQ analysis. So today's topic would be the continuation of President, Vice President and Governor. We'll be doing the part 2 of this particular topic. So let us start with this class. So the first question is, who among the following have held the office of Vice President of India? 1. Muhammad Hidayatullah. 2. Fakhruddin Ali Ahmed. 3. Neelam Sanjeeva. 4. Shankar Dayal Sharma. So this is actually a very factual question. So if you know the answer, you know. If you don't know, you don't know. So the first one is Muhammad Hidayatullah. Yes, this person was once, he was served as a Vice President of India. So he is there. And Fakhruddin Ali Ahmed and Neelam Sanjeeva, these both are, they served as the Presidents of India, but they never served as the Vice President of India. So we can eliminate this two options. Then Shankar Dayal Sharma, yes, he also served as the Vice President of India. So the correct answer would be B, 1 and 4 only. So the next question, the resolution for removing the Vice President of India can be moved in A. Lok Sabha alone, B. either House of the Parliament, C. joint sitting of the Parliament, D. Rajya Sabha alone. Now you try to answer this question. So let us explain this. They are asking about the resolution for removal of Vice President of India. So if you see, the correct answer would be Rajya Sabha alone. Why? Because you might have read that the impeachment or the resolution for removal of Vice President, it should be passed in both the houses, effective majority in Rajya Sabha and simple majority in Lok Sabha. But why the answer is only Rajya Sabha? The thing is, if you see the resolution, it should be passed only in Rajya Sabha by the effective majority. But what is that related to Lok Sabha is, after this resolution has been passed by the Rajya Sabha, the Lok Sabha has to just agree or approve this particular removal. So that is not, they are not passing any resolution. They are just supporting this resolution. They are just agreeing this particular resolution with simple majority. So we can simply say that the resolution for removal of Vice President of India is passed in the Rajya Sabha only, and it has been supported by the Lok Sabha with a simple majority. Okay, so let us have a look at here. A member of Rajya Sabha can introduce a resolution for the removal of Vice President. So this is the first point, that is, this removal resolution should be introduced only in the Rajya Sabha. They can't introduce the resolution, removal resolution in the Lok Sabha. That's not possible. Why? Because the Vice President is the chairman of the Rajya Sabha. So he is actually related to the Rajya Sabha, not the Lok Sabha. So the first point you should remember is the removal of Vice President. The first point is the resolution of removal should only be introduced in the Rajya Sabha and it can't be introduced in the Lok Sabha. This is the first point. Then second point, before introducing the resolution, a minimum of 14-day notice should be given to both the houses of Parliament. So before introducing this resolution in Rajya Sabha, a 14-day notice should be given to both the houses, not just Rajya Sabha. The notice should be given to both the houses. So this point you have to remember. Then this particular resolution is then debated and voted in Rajya Sabha, and how much majority is needed? It is the effective majority. What is effective majority? It requires the majority of all the then members of the house. Okay, so all the then members of the house, it should have the majority, and we can also call this as effective majority. So this is needed in the Rajya Sabha to pass this resolution. So the resolution is only passed in Rajya Sabha. Then what will Lok Sabha do? The Lok Sabha will support this resolution or will agree or approve this resolution. The Lok Sabha does not pass this resolution. It will approve the resolution. By how? By passing it with simple majority. So if the resolution has already been passed in the Rajya Sabha, it is sent to the Lok Sabha for consideration. Only the Lok Sabha has to consider. It should approve or disapprove. It's up to them. But they are not passing the resolution. So, for consideration, it is sent to the Lok Sabha. Then, this particular Lok Sabha, what they need to do, they need a simple majority to approve this particular resolution. What is simple majority? More than half of the members are present and voting. So the next question, under which article of Indian Constitution did the President give his assent to the ordinance on electoral reforms when it was sent back to him by Union Cabinet without making any changes in the year 2002? Now actually we can't remember, or we don't know what happened exactly in 2002. But what we can do, we can, with our fact, whatever static knowledge we have, with that we can try to answer this particular question. So with this given information, we can understand that they are asking about what is the article of Indian Constitution which is related to the President's assent to the ordinance. It is asking about the ordinance making power of the President. So we simply know the article 123 is related to the ordinance making power of the President. Simple. So we actually get the answer. But still, let us try to process what they are telling here in the question. So they are telling on the electoral reforms when it was sent back to him by the Union Cabinet without making any changes. So which means they are trying to say that there was some ordinance which the Council of Ministers or the Union Cabinet, they are asking the approval of President. They are asking the assent of the President for this particular ordinance which is related to some electoral reforms. And it is clearly visible that he has sent it for reconsideration and they have again sent to the President. So now he has to make the ordinance. So under which particular article he will be making an ordinance? That's what they are trying to ask. So again, the only option that is related to ordinance making power here is article 123. So that would be the correct answer. So if you see here, article 123 grants the President the authority to promulgate ordinances when both the houses of parliament are not in session. That is, we call it as recess. That is when both the houses, they are not in session, or either house is not in session, and the ordinary way of passing a bill and then getting assent from the President, that is not possible. Then there is some provision of ordinance making power given in the article 123 of the Constitution. Okay, we can't, like, suddenly we have to make a law, but we don't have time to wait to assemble the whole parliament. The parliament is not in session. Then in that particular case, the President has the power to promulgate any ordinance, and this particular ordinance has the same effect as a legal, like a law. The same, both the Parliament's law and the ordinance made by the President both have same power. The only difference is the lifespan of this particular both. Like the laws made by the Parliament, there is no, like the expiry, there is no mention of expiry. If there is any expiry, it will be mentioned in that particular law. But in case of ordinances, there is a expiry. That is, these ordinances have the same legal effect as the acts of the Parliament, but they are temporary in nature. And it typically ceases to operate at the expiration of 6 weeks from the date of Parliament reassembles. So when the Parliament again assembles, after that, within 6 months, this particular ordinance, it will expire. If you want to keep that particular ordinance, the Parliament should ratify this particular ordinance within a time frame. Then it will become a permanent legislation. Otherwise, it will expire. It will go. Okay. And if you see, these are some of the articles which was given in that particular question. They have given Article 121. So this Article 121 is related to, it prohibits the discussion. It prohibits the discussion in the Parliament within respect to the conduct of any judge of Supreme Court or High Court in discharge of his duties except upon a motion for removal of judge. What they are saying in Article 121, the Parliament cannot discuss the conduct of the judges of Supreme Court or High Court, so that they are not interfering in the working of the Supreme Court or High Court. Okay, except there is an exception when this particular session they are talking about the removal, the impeachment of the judges of Supreme Court or High Court, then they can discuss about that particular judge. But apart from that, the Parliament generally, usually, it can't discuss about the conduct of the judges of both High Court and the Supreme Court. And Article 122, it prohibits the courts from inquiring into the proceedings of the Parliament. So this Article 122 talks about the courts can't talk about the proceedings which are happening in Parliament. So both these articles are actually helping in the separation of power. The judiciary should not interfere in the legislature, and the legislature should not interfere in the working of the judiciary. So these both are related to the separation of power doctrine. And if you see Article 124, it talks about the establishment of composition of Supreme Court of India. It also talks about qualification of judges, tenure, and also the process of removal of the Supreme Court judges. So this is basically related to the Supreme Court of India. So the next question, consider the following statements in the Electoral College for the presidential election in India. 1. The value of the vote of an elected member of Legislative Assembly. Elected member of Legislative Assembly equals. 2. The value of vote of an elected member of Parliament equals. 3. There were more than 500 members in the latest election. So this question was asked in 2003. So by the static knowledge we have, we'll try to solve this particular question. If you see statement 1, the value of vote of an elected member of Legislative Assembly, that is the MLAs, they are talking about the MLAs, are equal. We have in detail we have discussed this in the part 1, like previous video. We talked about this, like the value of MLA's vote, it is calculated by a formula. What is the formula? The population of that particular state should be divided by the elected seats of MLAs in that particular state. So what will happen? The value of MLA's vote of each state will be different. They are saying that value of vote of elected members of Legislative Assembly is equal. They are saying that every MLA's vote value is equal. Is that so? No, it's wrong. Why? Because each state, the MLA vote value of each state are different, because the population and the elected seats of that particular Legislative Assembly are going to be different for different states. So the value is also going to be different. But they are saying it is same, it is equal. So this statement is wrong. Statement 2, the value of vote of an elected member of Parliament equal. They are saying that the value of MPs are equal. Again, we discussed this particular provision in the previous video. Yes, it is true. Each value of MPs are equal. Because if you see the formula, it is talking about all the states. It is not talking about any particular state, or it is not talking about the legislative, Lok Sabha or Rajya Sabha. No, every MP, even though he belongs to Lok Sabha or he belongs to Rajya Sabha, We belong to different states. No, there is no difference. Every MP, every vote value of an MP is equal. So this particular statement is correct. The third statement, there are more than 500 members in the latest election. This election held in 2003 or before that. Obviously, we don't have the knowledge of what happened in 2003 or before 2003. So, this particular statement, we can't come to a conclusion whether the statement is correct or wrong. So, but as I know the answer, this particular statement is wrong. It was more or less than this. So, the correct answer would be only to option B. So, you might ask, there are certain statements which are related to the current affairs of like very old years, like previous years, 2003, 2005, 1995. So, what is the point in doing the PYQ? So, technically, the current part, the current affair part of that particular year, we are not focusing on that. We are focusing on the static part, more of it. And we are also focusing on the language of the UPSC. These are the two important themes which are seen here. First, to recognize theme in the static part, how they are asking question in a particular topic. We are doing this topic-wise analysis to see how questions are asked in a particular topic. If you see, most of the questions are asked from governor and president. Very less number of questions are asked from the vice president. And how the questions are asked. If you see the value of MLAs and value of MPs, again and again, like 3-4 questions have come. So to see how the questions are evolving and how themes are repeated again and again, and also to understand the language of UPSC. These are the most important objective of doing the PYQs. And you should not focus on the current affairs part. Just leave it. Okay. So let us go to the next question. Which one of the following amendments to the Indian Constitution empowers the President to send back any matter for reconsideration by the Council of Ministers? A. 39th Constitutional Amendment, B. 40th Constitutional Amendment, C. 42nd Constitutional Amendment, and D. 44th Constitutional Amendment. So if you see here, before this particular amendment, it was more like this council. Obviously, the Constitution has clearly mentioned that the President has to listen to the Council of Ministers. He can't go against the recommendation of the Council of Ministers. If the Council of Ministers are trying to take a decision and they are giving it to the President, he must give his assent. He can't go against the recommendation. So moreover, what happened was this particular posting of President, it is more like a very ceremonial head. He has no real power. The real power is with the government, the Council of Ministers and the Prime Ministers. So what happens is, whatever they want, they have this ultimate power. So whatever they want, they can make it with their recommendation. But after the 44th Constitutional Amendment Act, what happened was, this particular amendment, it came up with a new provision. That is, the President has the power to send the recommendation of the Council of Ministers for reconsideration. So what is this? When the Council of Ministers are coming up with a recommendation, they are asking the President to do or take certain decision. Okay, the President can send it for reconsideration. He can say, please reconsider this matter. They can take time, they can reconsider. Okay, what will happen for taking arbitrary decisions? This will prevent it from taking arbitrary decisions. And now, if again they are sending it, again the recommendation without any changes, again the Council of Ministers are sending it to the President, then he has no other choice. He has to give his assent. But at least once they are giving the chance, even the bills, if you see, let's say both the houses of Parliament, they are passing a certain bill apart from a money bill. Obviously, the money bill, he can't send it for reconsideration. President can't send it for reconsideration. But apart from any money bill, any ordinary bill or any other bill, which both the houses of parliament, they have passed it and they are sending it to the president for his assent. Instead of giving his assent or withholding his assent, the president can send it for reconsideration. But again, if the same bill, again it is passed by both the houses and it is again coming to the table of president, he must give his assent. He can't again send it for reconsideration. So at least for the first instance, he can send it for reconsideration. So this particular provision was added in 44th Constitutional Amendment Act. So the next question, one of the following are or is stated in the Constitution of India. 1. The President shall not be a member of either House of Parliament. 2. The Parliament shall consist of the President and the two Houses. So they are asking which of the two provisions are stated in the Constitution of India. So if you see here, the President shall not be a member of either House of Parliament. Yes, the Constitution has clearly mentioned that whoever is going to be the President is not going to be the member of, he should not be the member of either House of the Parliament or even the member of the State Legislative Assembly. Okay, this is directly mentioned in the Constitution. So this particular provision is there. Then the Parliament shall consist of President and two Houses. Yes, this is also directly mentioned in the Constitution. The Constitution clearly says that the Parliament, that is the Lok Sabha and the Rajya Sabha, along with the President is mentioned. That is, the Parliament consists of 1. The President, 2. The Lok Sabha, that is the lower house, and 3. The Rajya Sabha, that is the upper house. So the Constitution clearly mentions that the President is the integral part of the Parliament. Why? Because the President has many important jobs to do regarding the Parliament. For example, when a particular bill has been passed by the Lok Sabha and the Rajya Sabha, both the houses of Parliament, until the President gives his assent, it can't become a law. And apart from that, the President has the power to summon the houses. He has the power to dissolve the Lok Sabha. So he has many powers which are related to the Parliament. So the Constitution clearly mentions that the President is an integral part of the Parliament. So this particular statement is also correct. So what is the correct answer? Both 1 and 2, both are correct. So the next question, which one of the following is a part of Electoral College for the election of President of India but does not form part of the forum for his impeachment? Option A, Lok Sabha. Option B, Rajya Sabha. Option C, State Legislative Councils. Option D, State Legislative Assemblies. So if you see here, they are asking that which one of this following body takes part in the election of the President, but it is not part of the impeachment process of the President. So we already discussed about the Electoral College of the President. Who are the part of the Electoral College? 1. That is the elected members of Parliament. And 2. We have elected members of State Legislative Assembly. And we also have the elected members of Legislative Assemblies of Union Territories, that is the Delhi and the Puducherry. So all these elected members of Parliament, State Legislative Assemblies and the State Legislative Assemblies which have the Union Territory, which have the State Legislative Assembly of the Union Territory. So these people are included in the process of the election of the President. But if you see the impeachment process, only the members of the Parliament, they are included the members of the state legislative assembly, they are not included in the impeachment process. So if you see, the correct answer would be the C, that is state legislative, not C, D, that is state legislative assemblies, because they are going to take part in the election, but they are not part of the impeachment. Anyway, the state legislative council, they are not part of the election also, they are not part of the impeachment also. And if you see Lok Sabha and Rajya Sabha, yes, these people are taking part in both election and the impeachment. So the correct answer is D, state legislative assembly. So if you see here, electoral college of the president, all elected members of Lok Sabha participate in the election representing the people directly, and all elected members of Rajya Sabha, they are also part of the electoral college, contribute to the election, providing a voice of the states, as the members of Rajya Sabha are the representative of the states, and elected members of all state legislative assembly, they are also participating, only the elected members, not the nominated members, and only the legislative assembly, not the legislative council, because most of the states, they don't have the legislative council. So these people are also participating in the election, and they are representing the regional parties. Then if you see the impeachment process, this resolution for impeachment can either be initiated in Lok Sabha or in Rajya Sabha. There is no condition whether in this house or that house. It can be either Lok Sabha or Rajya Sabha. And this resolution needs to be approved by the special majority. Here they are talking about the special majority, that is 2/3 of the members present and voting in each house of the parliament. Then the nominated individuals, if you see the nominated members of the Lok Sabha and the Rajya Sabha, they have not taken part in the election of the president, but still they are going to be part of the impeachment process. So the nominated individuals of either house of parliament may actually participate in the impeachment of the president, although they did not cast a vote in the election of the president. Then the elected members of state legislative assembly, these people, and the union territories of Delhi and Puducherry, these people will not take part in the impeachment even though they have taken part in the election of the president. So the next question, Article 156 of the Constitution of India provides that governor shall hold office for a term of 5 years. From the date on which he enters upon his office, which of the following can be deducted from this? Statement 1, no governor can be removed from the office till completion of his term. Statement 2, no governor can continue in office beyond the period of 5 years. So if you see here, Article 156, yes, it talks about the governor. The time period given for the governor is 5 years. Usually 5 years is given for a governor. But in statement 1, they are saying that no governor can be removed from his office till the completion of 5 years. No, this is wrong. Why? The Constitution clearly mentions that the governor holds the position with the pleasure of the president. What it means? It means that even before the completion of 5 years, the president can remove that governor from his post. So this statement would be a wrong statement. Then statement 2, no governor can continue in office beyond the period of 5 years. Again, this is wrong. Why? Because there are cases, even after 5 years, this particular governor, he can be posted again, reappointed again by the President of India. So he can continue his post. So this statement is also a wrong statement. So the answer would be D, neither 1 nor 2. So that's all for today's class. We have completed with President, Vice President and the Governor. So let us see in the next class. Thank you, students.